Good evening. My name is Mary Berry, and I am with the League of Women Voters of Albany County. Welcome to this candidate event for those running to become Rensselaer County District Attorney. This evening's event is being sponsored by the League of Women Voters of Rensselaer County. We wish to give special thanks to the RPI Chapel and Cultural Center for making this space available tonight. And thank you, the audience, for coming out this evening. It's wonderful to see you all here. The League is a nonpartisan volunteer citizen organization that promotes the informed and active participation of citizens in government. The League neither supports nor opposes candidates or political parties. The League has a long tradition of sponsoring candidate events to aid in educating the electorate so that on Election Day, voters will be able to make informed decisions at the polls. This year, the general election is on Tuesday, November 6th. The polls will be open from 6 a.m. until 9 p.m. For more information about the voting process and about candidates, go to the local League websites and the New York State League of Women Voters website, which has an online voter guide. This includes information from all candidates who responded to the League queries. The county and the New York State Boards of Elections websites have information as well. Just type in your address and information for you will come up. Be sure to read your postcard from the Board of Elections about where your polling place is located. The following ground rules have been agreed upon by the candidates in advance and will govern how we proceed. Each candidate will have 2 minutes for an opening statement, 2 minutes to answer each question, and 2 minutes for a closing statement. Each candidate has been given 2 red cards, they're sort of pink, to be used during the question and answer period. Each card will allow 1.5 minutes of additional time to be added to their response or to respond to something the other candidate has said. The League members are circulating with file cards. We need you to participate as well. Tonight, all the questions come from you, the audience. Write out your questions and the cards will be collected. The questions will be reviewed. They should be addressed to the particular office, not to a particular candidate, and be neutral in tone. They may be consolidated if similar. They will be eliminated if personal or illegible. I'm the one that needs to be able to read them. The questions must be able to be asked in 30 seconds or less. I realize that many people in the audience are fiercely partisan and exuberant supporters. However, we will insist that the candidates and the audience treat each other with respect. As I said, the candidates will have up to 2 minutes each to answer each question. They will alternate who answers first. The candidates have chosen lots to determine order of speaking. Our timer is sitting in front and will give warnings as the time runs out. Our timer this evening is Joan Rogers. Thank you, Joan. RPI TV has agreed to record the debate and air online on rpitv.org. The Sanctuary for Independent Media is also recording to air on its radio station, WOOC FM at 105.3. Only authorized media are allowed to record or photograph tonight's events. We ask everyone to respect this. Please take a moment to turn off all electronic devices as a courtesy to everyone. This is an informational forum, not a political rally. We ask that all campaign literature, signs, t-shirts, buttons, hats, be held until the formal part of our program has been completed. There will be time at the end for candidates to meet and greet the audience and to distribute campaign literature. Also, I would be remiss if I did not put in a plug for the League of Women Voters. Any person who is eligible to vote, female or male, may become a member of the League. Please see any League member afterwards for membership information. This year, there are 2 candidates running for District Attorney of Rensselaer County. In alphabetical order, they are Joel Abelov, running on the Republican, Conservative, and Reform lines, and Mary Pat Donnelly, running on the Democrat, Independents, Working Families, Green, and Women's Equality lines. The district attorney is the chief prosecutor of the county. The DA is responsible for the prosecution of all criminal matters arising in the county under the laws of New York State. The candidate must be a member of the New York State Bar. The term is for 4 years, and there are no term limits. The current annual salary is $194,845. The candidates have drawn lots to determine order of speaking. Then the candidates will alternate at my direction. Remember, this is a time for you to learn about the candidates in order to make informed decisions on November 6th. Please write out your questions and hand them in to League members. I ask that you hold your applause until the end of the program. Thank you in advance for demonstrating your civic concern by attending this event. I want to thank the candidates and the audience for the respect I know you will show throughout the evening. It is now time for the opening statements of no more than 2 minutes. And first, we'll hear from Mary Pat Donnelly.
Good evening, everyone. Thank you all for being here, and thank you for the League for putting this together. I think it's very important that you all hear directly from us about our vision for the office going forward. And I look forward to hearing all of your questions. My name is Mary Pat Donnelly, and I'm running for Rensselaer County District Attorney. I have lived in Rensselaer County for most of my life. I'm a graduate of Columbia High School, University at Albany, and Albany Law School. After law school, I moved out to our neighboring state of Vermont, where I did work briefly as a prosecutor in the Bennington County State's Attorney's Office. But for the last 20 years, I have worked for the unified court system in New York State, in the criminal courts, with judges as a court attorney. And what a court attorney does is sits with judges on a daily basis, observing trials and hearings, and we make decisions with respect to points of criminal law. With the judges that I have worked for, I have written thousands of decisions on speedy trial issues, prima facie issues, suppression issues, and other important matters relating to criminal trial procedure. As a result of my work as a court attorney, I'm intimately familiar with the rules of criminal trial procedure in New York State. Additionally, for the last 6 years, I've sat on the bench in my hometown of East Greenbush as a judge. I was appointed in 2012, and I was elected in 2012 and again in 2016. It was a job that I very much enjoyed, and from sitting on the bench, I had a chance to watch the criminal justice process from both sides, from the defendant, as well as from the district attorney. And it is from that position that I was able to observe the current district attorney's office. And I want everyone to know that my decision to enter the race is not a partisan one. I am not here as a Democratic challenger. I am here as a judge who has observed the function of the current office and feels that I have something to offer the citizens of Rensselaer County. Thank you.
Thank you, Mary Pat. Now we'll hear from Joel Abelov.
Thank you. Good evening, everyone. Thank you so much for coming out tonight. My name is Joel Abelov. I am proud to serve as your district attorney. I'd also like to thank the League of Women Voters and RPI for hosting the event this evening. I think it's very important that voters get to hear the qualifications of the candidates when they're deciding who to vote for the office of district attorney. Every day when I wake up, I have one mission. That mission is to join with my fellow staff, and most of my ADAs are here this evening, And that mission is to protect the residents of Rensselaer County and to hold criminals responsible and to seek justice. We work very, very hard and very long hours in that mission, and I've done that my entire career. And I'm proud to say that our office was able to achieve a roughly 90% conviction rate for all of the long, hard hours that my staff and I put in. But even more proud than just a number, I must tell you I'm very proud of the support and the gratitude that I've received over many, many years from victims of crime and their families, because being a prosecutor is about being passionate about what you do in seeking justice, and there's really no greater feeling, no greater satisfaction for a prosecutor than to know that you're helping people out and getting justice for those victims of crime. I'll tell you, on top of and besides being able to get that conviction rate, it was done in the face of some serious opposition, and I mean good opposition from a very qualified defense bar, but also opposition politically. It's no secret that I've been targeted by Governor Cuomo, our former Attorney General Eric Schneiderman, our now disgraced former Attorney General who resigned in the face of some serious domestic violence accusations, and I've weathered that storm. I have fought back those charges in court and they were dismissed, and I appreciate everybody being here, and I look forward to answering all of your questions and discussing my experience. Thank you.
Thank you. Now we'll begin the portion of where I ask the question, and the two candidates alternate who goes first to answer that question. Each candidate will have 2 minutes to answer the question. The first question will be answered first by Joel, and the question is a continuation of your opening statements. Please describe your qualification and experience and how that makes you the best candidate for the job of District Attorney for Rensselaer County. Please include discussions of the role of a prosecutor and combined with being a department manager.
Thank you very much. That's an excellent question, and it's probably the best question we can answer here tonight about our qualifications. I started out as an intern in this office while I was in law school. I actually interned for the Albany County District Attorney's Office for 2 semesters as well. I started right out of law school in the DA's office here in Rensselaer County, and I worked my way up. I was an assistant district attorney. I was a bureau chief of our special victims unit. I was our chief assistant district attorney. I worked for 3 different district attorneys actually for the 10 years that I spent initially in the DA's office, prosecuting cases, trying cases, all sorts of cases, misdemeanor cases, felony cases, you name it. I've tried everything pretty much in the penal law, and I've appeared in all of the courts in Rensselaer County doing so. I then spent 9 years as a prosecutor for the state health department, prosecuting physicians and physicians' assistant for misconduct under the public health law, holding physicians accountable for their misconduct, again, trying those cases in administrative hearings, developing those skills that every prosecutor enjoys developing throughout their career. Since being elected as district attorney 4 years ago, I certainly haven't shied away from being in the courtroom. I've tried cases, some very difficult cases, homicide cases, arson cases, burglary cases. These are cases that I've personally indicted and personally handled in court. Just last summer, I tried and convicted the convicted parolee who murdered a good man, Bill Chamberlain, near his Wine and Skill home. I took it upon myself to indict that case and to try that case because I believe strongly in it. And I'm currently prosecuting the quadruple homicide case from last Christmas time from the city of Troy because I believe so strongly in that case that I took it upon myself to handle it personally. I've developed the managerial skills over a career of being in the DA's office and supervising people, 23 years in the Army serving as a supervisor there and prosecuting cases also. Thank you very much.
Mary Pat.
Thank you. And this is an important question because many people have said, why is it that you want to be the top prosecutor in Rensselaer County when you are not currently a prosecutor? And that is exactly the reason that I believe I can fix what is broken in Rensselaer County. You have your experienced prosecutor, and you have the record that he stands on. I don't know where he got the 90% conviction rate from, because I too looked at the DCJS data, and there is an 89.5% conviction rate for drug felonies, but overall felony conviction rate is around 68%. And what you really need to know is that it was higher when he took office, and it has steadily declined during the last 4 years. These are the concerns I have as someone who has lived in Rensselaer County for most of my life, and someone who has worked in the criminal courts of New York for almost the entirety of my career, which is 20 years. And I have seen the problems with his office as a judge in the town of East Greenbush. And I have recognized that something is wrong. I don't know what it is. I do know that there has been an extremely high turnover in his office. Over 30 attorneys have left during his tenure. I do know that multiple cases have been dismissed on speedy trial grounds, and we've heard all kinds of crazy numbers, but at least 400 felonies were never presented to a grand jury. These are the reasons that I am stepping into the race, and I'm bringing forth my experience as a court attorney and a judge, and not as a prosecutor, because I think what the office needs is not a major overhaul, but it needs leadership, and we need to create an environment that attorneys want to work in.
Thank you.
If I may, I need to address a few of those matters. I'd like to. Thank you.
1.5 minutes.
Thank you. I'm not sure how my opponent is going to utilize whatever leadership skills she claims to have, but as a court attorney for the last 20 years, I don't believe she's had any need to have any leadership skills. I can tell you that much of the statistics that have been cited by my opponent are basically statistics parroted from media accounts which have been inaccurate and which I've debunked in social media posts. You know, for all the time that my opponent spent on the bench while I've been district attorney, I've never heard a complaint from her or her court or the other judge that sits in her court or any of the other judges in Rensselaer County. There are 17 other city, town, and village courts in the county and 2 county court judges, and none of them have ever complained to me about my office being in disarray or any of the other terms I've heard my opponent use. The numbers of cases about being dismissed, I can tell you that when I came into office, there were scores of cases laying around that had already died, that had never been dismissed, that my office was tasked with cleaning up and dismissing because they had never properly disposed of those cases. So to quote statistics without any background or factual basis behind them, I think is entirely misleading. I dispute those statistics. My office has done a tremendous job at cleaning up the mess that was left. We've also instituted computer systems in the office that assist the attorneys with case tracking and time limits, and I would just ask you all to consider that.
Thank you, Joe.
Thank you. Thank you.
The next question will be answered by Mary Pat first. The question is, do you support alternatives to incarceration? If so, please give an example of how you would do so.
I absolutely support alternatives to incarceration. We have to look at what we're accomplishing and who we're accomplishing it with. Now, first, I'd like to start off by clearing the air and letting everyone know I have no intention of failing to prosecute violent felons. I have no intention of looking at restorative justice practices for any serious crimes. But what I do think we need to look at is the fact that we are a small county with a high crime rate, and we have a small budget to work on to take care of all of the crimes that come through the office. And I think we need to take a look at some of the minor crimes where we have first-time offenders, nonviolent matters, and we can possibly put those through a restorative justice process. Now, what that is where we take it from the people of the state of New York prosecuting in the name against the defendant, and we turn it into the offender and the offended. And they take it out of the court system, and they have a meeting with a party who would help them understand how the actions of the offender affected the offended party. And you can resolve it without the work of the courts. These are things that I think can be applied as a start. First, we need to get the office back to its running state, and then explore the options of restorative justice. Additionally, we do already have an up and running drug court, which is doing a wonderful job, that provides somewhat of an alternative to incarceration so long as it is successful. And of course, I would support that as well.
Thank you. Joel.
Thank you. Well, my office is very involved in alternatives to incarceration. We participate in both the drug and alcohol treatment courts on the county court level and on the misdemeanor court level, which is held in Troy City Court. Our office screens appropriate defendants who are qualified under the law to participate in those programs and who wish to participate in those programs, and they're difficult programs to go through. Some defendants choose not to go through them, and they actually choose jail time because it's too difficult for them to undergo the treatment. But for those defendants who wish to go through the program, we are very active in assisting them in doing that. I sign their certificates of graduation along with the judges and the attorneys, and we're very proud of that. There are other alternative to incarceration programs that we participate in. There's used to be called the Sheriff's Work Order Program. It's actually called Alternatives to Incarceration, ATI, where we assist in sentencing defendants to alternatives to incarceration, where they go out and they do various types of work in the community and community service. I think these are very practical and effective alternatives to incarceration, and I'm very proud that my office participates in them.
Thank you. The next question will be answered by Joel first, and it is, I am from rural Rensselaer County. How often do you visit the local courts for oversight, consistency, and visibility?
Well, I've certainly appeared in all the local courts during my career. I have a very trusted and trustworthy staff who appear in those local courts. Excuse me. It's just dry in here. I've been out to some of the local courts to do that. Excuse me, I've covered those local courts myself. I've been out to Nassau. I actually did a trial 2 months ago in North Greenbush Town Court. So it's very important to me, and I do have supervisory staff that goes out and assists me in that task in viewing what's going on in those courts. In fact, when attorneys are new in the office, they are required to go out with more experienced attorneys who have handled those courts so they can train them and how those particular courts work, how the judges and the clerks in those courts work, how the public defender and the conflict defender in those courts operate, and to become familiarized with the practices of each particular court. So that's part of our in-house training program, is to ensure that new attorneys coming in get properly trained and mentored.
Thank you. Mary Pat.
With all due respect, in the 6 years I sat on the bench in East Greenbush, Mr. Abelov never set foot in my courtroom. And to backtrack on what we were discussing before, I frequently attempted to reach him and was not granted a return phone call. So that's completely inaccurate. I think it's very important that the district attorney visit the local courts, because they need to know, in some of these local courts, we don't even have lawyers as judges. So it's quite important that the staff that's being sent to these courts know what they're walking into. And having sat as a judge and having worked with so many judges, I have the ability to assess, I think, rather quickly what style a certain judge has. So I think that will be a benefit to my staff, that I'll be able to visit these courts and let them know what the judges they're going to be dealing with are like.
Thank you. The next question will be answered by Mary Pat first, and the question is, although the jail population is in decline in Rensselaer County, it is higher than the national rate, according to the Vera Institute of Justice. How would you address this? Would you provide for those in need of mental health services, rehabilitation, and/or job training?
Can you repeat the second half of the question?
How would you address this? The Rensselaer County has, the jail population is higher than the national rate.
Okay. Well, I think the district attorney has a role over and above prosecution, and that is to assess the people that come before its body and determine what's best in terms of assisting that person if they're going to be entering back into society. So I do think that obviously scanning defendants for needs for mental health counseling or any type of drug treatment is certainly beneficial and important. And I think it's important because we want to make sure that when these people have gone through the criminal justice system, that maybe they won't come back. So I do think that it's very important that when you are dealing with a defendant, you're dealing with them as a whole person. And it's very hard to balance this with the need for safety. And I certainly don't mean to come across to say that the function of the prosecutor is to help the defendant. But certainly when you're making your charging decisions and you're screening your cases, you're going to want to see if the crime that's being charged has something to do with someone's mental health state or an addiction problem. And if we can ferry those people into treatment and get them the help they need, perhaps outside of the criminal justice system, or perhaps by utilizing a drug court type of a situation, that might actually be the best thing for that person.
Thank you. Joel?
Thank you. The primary responsibility of any district attorney, first and foremost, is to seek justice. Justice can take many forms. It depends on a whole host of factors. My office is very involved in assessing the strength of a case and what's an appropriate outcome for a given case. We work closely with the defense bar when they bring us information about their client's mental health status, their substance abuse status, and we help fashion outcomes that we believe will address the concerns first and foremost of the safety of society, holding offenders accountable for their actions, and trying to ensure that they don't reoffend. My office happens to be a partner in what's called the Parole Reentry Program. We have a grant from New York State, and we employ a coordinator that coordinates these very services for parolees, because we recognize that when people get out of state prison and come back into the community, they need to be supported. And my office does those very services. We ensure that parolees have access to employment training, mental health and substance abuse counseling, education, housing, all sorts of things that can enable them to get on their feet and become productive citizens. I'm very proud of that program. It's very, very successful in our county, and we continue to be recognized by the Division of Criminal Justice Services, who administers that program, because it is an important component of what the district attorney's office does, and that wasn't always the case. When I started in the DA's office many, many years ago, we didn't have that program, and I'm very proud that we run that program out of my office, and that we do such a good job at connecting these parolees with services in the community, not-for-profits who bid on the money that we're able to administer so that they can get the assistance that they need.
Thank you. The next question will be answered by Joel first, and the question is, DAs across the country, are committing to transparent practices. If elected, will you commit to robust data collection and sharing with the public? For example, collecting data on bail, pleas, and diversion programs.
Well, I think we already have a lot of data on diversion programs. That's something that, that the courts track, as well as bail, which they track as well. Data on pleas, I'm not sure how that could be collected effectively. Plea bargaining is a very, very fluid process. It's very much a back and forth between the prosecutor's office and the defense bar, and even the courts who get involved in the plea negotiations, because any plea bargain is a three-way agreement with all parties having to agree on the outcome. I hesitate to say that it should be something that is tracked. I wouldn't want the fact that that negotiation process is being tracked to influence anybody's good faith negotiation. And I also don't think that it's appropriate for different sides to have to go on record with the public as to what plea negotiations took place, especially for defendants. I think that's very dangerous. I think defendants should feel free to approach prosecutors, as their attorneys often do, and recommend certain plea bargains that their clients are willing to accept. If they knew that they had to be on record as to what they were suggesting for a plea bargain, I think that could have a real chilling effect on defendants' willingness to engage in that process, and that would hurt their clients. So I don't necessarily think that that's an effective tack to take. I'm all for transparency. I think you know, the bail issue is certainly out there for everybody to see. Everybody knows how much bail is set on a given case in the defendant's case, because that's a matter of record.
Thank you.
Thank you.
Mary Pat?
Absolutely, I agree. I think transparency is very important to instill public trust. The question becomes, how do we commit to a robust transparency, and how do we put that into work in the confines of the office that we have. I think that with respect to bail, that is something that is tracked by the courts. I can certainly speak to that. And I can understand why people want to understand how bail is set and why bail is set. And that is certainly a hot topic. I can say that from my experience on the bench, I think I have a unique view of what bail is for, and I could bring that to the district attorney's office. Bail is not punitive. Bail is set to make sure the defendant comes back to court. And I think that, unfortunately, as I stated earlier, a lot of town court judges are not attorneys, and they need to understand that. They need to understand the purpose of bail. And we're seeing in different parts of our state where bail is being abused. So I would commit to any type of transparency to track what's going on within the office. You just have to be careful that you're not within the confines of anything that's privileged.
Thank you. You'll answer this question first.
Okay.
The question is, in light of the opioid epidemic, what are your thoughts on the special drug court?
I think that drug court is a very, very beneficial process. In fact, when I was in Albany City Court 20 years ago was when we began our first treatment court there, and we saw what it can offer to certain defendants. The opioid crisis here in Rensselaer County is in a terrible place. And I have to say that I think Rensselaer County has taken some very important measures, trying to raise awareness, obviously, and to offer help to people that need it. I think that a specialized treatment court for opioids would certainly put those folks who are battling that addiction in a separate place away from those who are dealing with other addictions, because it is different. And it definitely is targeting a different demographic. So I would fully support anything we can do to make inroads with respect to that crisis, and I would work hand in hand with Rensselaer County because I think we've already put some really good programs in place.
Thank you. Joel?
Thank you. Obviously, my office is very involved in the drug treatment courts that currently exist. I'm a member of the Rensselaer County Heroin Coalition that was started a little over 2 years ago. We meet regularly to discuss the issues. The group started from just a few of us to now having over 700 members of all folks in the community from all different disciplines. I've seen in the DA's office firsthand with the cases that we prosecute the horrendous impact that heroin and opioids have had on crime in our county. So many of our defendants are committing crime, if not directly related to the drugs and having the drugs or selling the drugs themselves, but committing crimes in order to support their habits. The larcenies, the burglaries, robberies, etc. Many of these defendants are committing these crimes in order to support their drug habit. I believe just recently there was a directive that came down from the chief judge requiring that there be an additional heroin or opioid treatment court on top of the drug treatment courts that we have. So I look forward to working with the judge in the county who handles that to work on that, the implementation of that if that certainly comes to fruition. But I can tell you it is a horrendous problem. My office is assisting to pay for the very recently established opioid coordinator in Rensselaer County. We've set up a hotline so people can call and talk to somebody and get help. These are all very proactive steps that the county has taken and that I've taken along with them to help combat this crisis. I've also partnered with the United States Attorney's Office, the Sheriff's Department. We've traveled around to various schools around the county to help educate the community about the severity of this crisis and what the community can do to be involved. And I'm very proud of the work that we've done in that regard. Thank you.
Thank you. The next question is, do you support treating minor infractions as non-criminal offenses? Why or why not?
Well, very minor infractions are already non-criminal offenses. They're called violations under our law, and there are many types of them, from harassment to disorderly conduct to possession of small amounts of marijuana. So the law already treats very minor infractions as non-criminal, and I support that. In fact, there's recent sealing provisions that were enacted by the legislature last year that allow those who have convictions that are at least 10 years old or older for crimes to have their records sealed if that's the only thing they basically have on their record. And I, along with the DA's Association, supported that effort as well. to ensure that people who committed a crime perhaps in their youth many years ago and they've been law-abiding citizens since shouldn't have that stain on their record affect them for the rest of their lives and their careers. So yes, the answer to the question is I'm all for treating very minor offenses as non-criminal. We do that now, and I anticipate that'll continue to be the practice statewide as the legislature continues to review the nature of offenses and decides what's appropriate for their level of culpability.
Thank you. Mary Pat?
I would give basically the same answer. Minor offenses, I'm not sure what exactly they were referring to, but minor offenses are violations and they're considered non-criminal. Unlawful possession of marijuana is one of those non-criminal offenses that people often talk about when they talk about a minor offense. And these are non-criminal offenses, but they do bring someone into the realm of the criminal justice system. And I have to say that with respect to any charge, you have to look at it on a case-by-case basis. And in some situations, bringing someone into the criminal court for a non-criminal offense may have a certain benefit to them. Sometimes it's a young person who needs to be brought in front of a judge and who needs to have some fear instilled in them so that they make better choices going forward. So I absolutely support what I know to already be the law, but I do see the benefit of having these charges remaining on the books so that the officers can use discretion when they're out in the field and charge appropriate defendants with them as needed.
Thank you. The next question is, the issue of police misconduct has become an issue nationwide. When the police are the subject of an investigation, do you ever think it would be appropriate to bring in a third party to carry out the investigation?
I absolutely do. I think most of you may know my background. I am married to a police officer and I was raised by a police officer. So I certainly love and respect the work that police officers do. And I think we all know that sometimes in the course of their duties, situations occur and we have that blurred line where we have to find out if their actions were justified. And I would certainly support measures that would take that out of the hands of a small district attorney's office like Rensselaer County and have an impartial individual or impartial body investigate that particular situation. You cannot deny the working relationship and the personal relationships that are going to develop when you have police officers working hand in hand with prosecutors on a daily basis. And unfortunately, we are where we are in our world right now, and there is a horrible distrust of the police. And that actually, it bothers me very much because I grew up with my father as my hero and my husband as well, and looking to the police for safety and solace. And unfortunately, not everyone feels that way anymore because of the actions of certain individuals and the way that certain people have spun what's going on in our world. So we have to just acknowledge where we are without laying blame, that there is an absolute distrust in certain areas of the police. And as a prosecutor, we have to acknowledge it and make certain concessions moving forward.
Thank you. Joel.
Thank you. Well, I'm going to disagree with my opponent a little bit on this answer because I think everybody understands that the police have a phenomenally difficult job in this day and age. I think that by suggesting that prosecutors cannot be fair and impartial in carrying out their sworn duties, we are feeding into a false notion that prosecutors are somehow biased towards the police. I've prosecuted police officers during the course of my career for DWI. I've prosecuted corrections officers for for a sex offense with an inmate. There's nothing in my background or any good prosecutor's background that would lead me to believe that they could not be fair and impartial when assessing the evidence in a case, no matter who the suspect or the defendant is. I will say that I think that any prosecutor should recuse him or herself in any case where they have a personal conflict of interest with a particular police officer or any other defendant, and my office does that on a regular basis. We do letters of disqualification and ask that special prosecutors be appointed by our county court judge whenever we believe there's a conflict of interest that may adversely affect the appearance of the case or certainly affect the outcome for a defendant. But I reject the notion that prosecutors are automatically biased in favor of police officer defendants. And to suggest that small offices are somehow going to be more biased than potentially a larger office, I disagree with as well. And finding the supposed neutral third-party prosecutor, I think is very dangerous as a concept to say, well, who picks that person? Because the district attorney is responsive to their electorate, the people who put us in office. And there's a current construct in place where the prosecutor who gets appointed is not held accountable by the county in which they may be operating.
Thank you. Thank you.
I'd like to use my red card on that.
Certainly. 1.5 minutes.
Thank you. Ladies and gentlemen, it's the appearance of impropriety. I would not suggest that because you work in a small office, you're automatically biased in favor of the police. I don't think that at all. I think there are good men and women working in the Rensselaer County District Attorney's Office who know how to be impartial. But as I stated in my previous answer, we are in a place in our world, in our state, in our county right now, where there is distrust for the police. I regret it. I don't like it, but it is what it is. And as a prosecutor, as someone who is part of the law enforcement equation, you have to eliminate any appearance of impropriety in order to help rebuild that trust. Unfortunately, we are charged with that responsibility because of the state of our country today. So it is not because I think that a prosecutor in Rensselaer County cannot be fair and impartial. It is because I think that it is very important, just as judges do, that we eliminate any appearance of impropriety by seeking out another body to do that prosecution and investigation.
Thank you. This next question will be answered by Joel first. The question is, to whom is the district attorney accountable?
Well, as I mentioned a moment ago, the district attorney is accountable to the people, and I think that's what's most important, especially when revisiting that last question, is that the electorate in every county, in all 62 counties, is responsible for holding their district attorney accountable, which is why if you have an outside prosecutor who's not accountable to that electorate within that county, there's a real risk that the actions they take are not going to reflect the values and the judgments that that electorate has when they select their district attorney. That's why we have a system in New York State where every district attorney is selected by the voters of that county, so they can be held accountable by their electorate. And I think that's a good system that we have. I agree with it, and that's the accountability that we have, is the electorate. Certainly there's the Bar Association and the Appellate Division exists, as they do to hold all attorneys accountable in instances of alleged misconduct. But as far as the judgments that a district attorney exercises within his or her office, that accountability is to the people and directly to the people.
Thank you. Mary Pat?
I don't wholly disagree with Joel on that. However, I think the district attorney is responsible to the truth. And if the truth can't be found under the circumstances of a particular case, you have a responsibility to pass that on to someone who can. You are responsible to the electorate. You are responsible to the people of the state of New York, because that is in whose name you are doing your prosecution. But if your attempt to seek justice is going to be clouded by a particular aggravating factor in any case, you have a responsibility to declare that and to find someone else who can do the job. So I don't disagree that you're responsible to the people, but I think we need to know we're responsible to the truth first, and we have to make sure that the situation that we create will help us find the truth.
Thank you. The next question is, do you support the end of the system of cash bail? Why or why not?
I don't support the end of a system of cash bail. I, as a judge, imposed bail on a frequent basis when it was necessary. And as I stated previously, I think I have a good understanding of the purpose of bail. The problem we have in New York State is that, and I'm going to pass this on to the judges because I don't actually think it's the prosecutors who have a misunderstanding, because they're only making the recommendations. It's the judges who are imposing the bail. The problem in New York State is that many of our judges are not lawyers in the town courts, and then when we go down to New York City, we have judges who are randomly setting bail, cash bail, that people simply cannot afford. So while I appreciate the idea that we don't want people incarcerated because they can't afford to pay, I don't think eliminating cash bail is the answer. I can tell you that when I had someone in front of me in town court, I would do my very best with what I had, with the help of both attorneys, to figure out what this person's lot in life was, and if they were going to come back to court, and if I had an absolute concern that they weren't coming, what amount of money is going to entice them to come back. And when someone was to see me on a fine and to make a payment, I always made sure that we had a person-to-person understanding. This is not about the money. If you don't have the money, you come back to court. You come back and see me, and you will not end up in jail. It's about respect for the system, and it's not about putting people in jail because they are poor. I have a very big concern about ending the use of cash bail because I feel that there are certain circumstances in which we really need it to make sure that violent criminals come back to court.
Thank you. Joel?
Thank you. I also am not in favor of ending cash bail. My office makes bail recommendations. By law, we're required to make recommendations on felony cases. On misdemeanor cases, unless my attorneys happen to be in court when a defendant is arraigned, then we're not present at all when bail is set by judges. And that can happen any time, day or night, when the judges are available. Bail is important because it does serve a valuable purpose in ensuring that defendants show back up for court. And I think it's important to understand that when defendants don't show up for court, they face bail jumping charges potentially, but also forfeiture of their bail. And to disincentivize defendants from showing up by eliminating a tool that judges have to ensure their appearance, I think is a mistake. So bail is very important. The judges in Rensselaer County that I've seen over the years do a pretty fair job of assessing the various statutory factors that are supposed to go into what bail is being set. Sometimes that isn't the case. Sometimes you see very, very low bail set on a very violent offense. And in those instances, my office will hopefully have the ability to revisit bail if we indict that case and come before a county court judge where we can ask the judge to reconsider the bail that was set in the local court so that we can have some input into protecting the community and ensuring that somebody does return to court when they're supposed to.
Thank you. I'm going to take a little break and ask this lady in the front row to please put your camera away. Okay, but it looks like you do. Well, thank you. If you could, thank you. The next question will be answered by Joel first. The question is, what is the role of the DA with regard to addressing child abuse?
Well, that is a very complicated question, but it's something that I have a lot of experience with. As the former sex crimes prosecutor for Rensselaer County and the bureau chief of our special victims unit, I've attended trainings all over the country, and I've handled, unfortunately, so many cases I can't even recall cases of child abuse, both physical abuse and sexual abuse. A lot of those resulted in trials that gave me a lot of my trial experience when I was an assistant DA. The role of the district attorney with regard to child abuse is multifaceted. Certainly, first and foremost, we want to help ensure that the child is going to be safe, that the child is going to receive all of the counseling and services that that child and their family members, the non-offending family members, need to receive to make sure that they're going to be made as whole as possible. They'll never be able to be restored to the condition they were before the abuse, but it is incumbent upon us as district attorneys to ensure that these victims and their families receive the counseling that they deserve and that they should expect from the criminal justice system. Additionally, it's certainly incumbent upon the district attorney's office to ensure that we fight as hard as we possibly can to get justice for that victim. All victims have a very hard time going through the criminal justice system. Child victims of abuse have an extraordinary difficult time. I can tell you from personal experience of walking these kids through these cases over the years, it's another trauma to them beyond the abuse. And the fact that they have to come into a courtroom and talk about what happened to them in front of a room full of strange adults is extraordinarily traumatizing. And a good prosecutor who is experienced in handling these types of cases will be adept at helping to guide them and their family through a very, very difficult process. So I see the role of district attorney as very comprehensive and vital to assisting victims of abuse, especially child abuse.
Thank you. Mary Pat?
Certainly, child abuse victims are most vulnerable, and obviously, it's a multifaceted issue, as Joel had stated. They're some of the most difficult cases to deal with because you have so much going on with these young children. They're trying to tell their story. They're trying not to betray someone of trust. They're trying to navigate through the criminal justice system, and they're simply dealing with the harm that they have been afforded. So the district attorney's role is obviously to seek justice on their behalf. And from all accounts, we have a wonderful victim services unit in the district attorney's office that guides these children through probably the most traumatic events of their life. I actually have a nephew who was a victim of child abuse, and I tried to guide him through the process. When he wasn't with the district attorney, we would talk about what's going to go on in court and how you're going to be able to do it. And I remember the heartbreak we all had when we got him to court and he simply could not speak. So I have a personal appreciation for what we need to do for these children so that they can tell their story. And I do think that right now the Victim Services Unit, by all accounts, does a great job of helping these children through one of the worst experiences of their lives.
Thank you. The next question is, would you take into consideration a person's immigration status in deciding whether to prosecute or not?
Every case is going to have to be evaluated based upon a multitude of factors. Immigration status would not be a deciding factor. I can tell you that as a judge, on many occasions, I have had some individuals in East Greenbush Town Court who had immigration issues, and what we always did is we gave plenty of time for their attorneys to inquire as to what was going to happen as a result of any plea that they might take. I think we need to be sensitive to the situation of individuals that come before the court, but at the same time, we have to balance that with public safety. So if you're talking about an individual who, for example, has a warrant for their arrest, I certainly don't think that their immigration status should bar us from executing that warrant. Should we be digging into the immigration status of every single person that comes before the court as district attorney? Probably not our function. It's more of a federal function. It's more of a civil issue. But as district attorney, if I became aware that a defendant in front of me had an immigration concern, such as a warrant, I do think that it's my obligation to execute that. It's a real balancing act with immigration, because we have to weed out the people that are here seeking what we love about our country and the people that are here to harm us. And it's a really tough thing to do. Our immigration system is broken. You don't need me to tell you that. And we need to work very hard as a country to fix it. And the criminal justice system is certainly one spot where we have to figure out how we're going to weed out those people that are a danger to us and those that have come to our country seeking solace.
Thank you. Joel?
Thank you. I don't think immigration status should play into a prosecutor's consideration at all when deciding what sort of justice you're seeking. Justice is justice. It's supposed to be blind. It's not supposed to depend on the color of your skin. It's not supposed to depend upon your religion, and it's not supposed to depend on your immigration status. If you're here and you commit a crime, that's the first thing that brings you into the criminal justice system and before a district attorney's office. If we later learn that you happen to be in the country illegally, that's just another issue to be dealt with, not by the district attorney's office, but it gets dealt with by the courts, who are required to advise defendants before they plead guilty how that guilty plea may affect their immigration status. And it's dealt with by the federal government that enforces our immigration laws. So as district attorney, I don't consider somebody, if they happen to be in the country illegally, I don't treat them any easier or any harsher because of their immigration status. I look at what is the crime, what did they do, what is their history, if they happen to have a criminal history that we're able to become aware of, what's the impact upon the victim, what's the cost to society, what does justice demand in a given case. There are defendants who we're prosecuting currently for homicide who are here in this country illegally. The people who they were alleged to have murdered were also here illegally. I don't treat that case any different because of the immigration status of either the defendants or the victims. Thank you.
Thank you. The next question is, how do you fight cyber crime?
Thank you. I'll tell you, talk about an emerging area of the law. As is common with many areas of the law that get developed, technology always seems to beat law to the punch. The legal system and our legislators are always playing catch up with the latest technology. When I started in the DA's office, well over 20 years ago, we didn't have nearly the technological issues that we face today. We didn't have social media. There wasn't anywhere near as much use of the internet to commit crimes. So there's a whole lot of cybercrime that goes on, and they're very difficult cases to prove at times because people can commit these crimes from anywhere in the country or anywhere in the world. People can steal your information, make purchases on your accounts, and trying to track them down and actually hold them accountable and prosecute them is very, very difficult, especially for a district attorney's office that doesn't have the reach that the federal government has. It's been my office's practice to partner with our federal agencies whenever possible, whether it's the United States Secret Service, whether it's the FBI, whether it's the DEA, any of the federal agencies that have a lot more of the resources and the capability to help us investigate these matters. Because the truth be told, if you say I've had my credit card stolen from an online purchase somewhere, it's very difficult because state subpoena power has its limitations when we try to find out information that may be around the country, and it's next to impossible to try to find out information of people who are overseas who are doing this type of thing. So it's a tremendous challenge for all of law enforcement, and it's certainly a challenge for district attorneys everywhere.
Thank you. Mary Pat.
It certainly is an emerging area in the law. As a mother of 5 children, I am seeing on a daily basis how much time young people are spending on their phones. And certainly there's cybercrime, as Joel talked about, with people stealing credit cards and things of that nature. But then what I had seen at the town court level is more of the harassment crimes that we see through Facebook and social media. And that is certainly an emerging area of the law. You have your jurisdictional questions, you have your actual harm queries, whether or not the person was actually going to do what they threatened to do on social media. We're breeding a whole generation of kids that hide behind a screen and say things that they might not actually do. However, in the world we live in, we have to take these threats seriously. And the ease of use that our youth have right now of cyber technology and of social media, it's really bringing a whole new realm into the law. So, as district attorney, you prosecute the crimes that are on the books, and you certainly hope that as our country is evolving and we are seeing crimes committed in a different fashion than they were when the laws were drafted, that the laws are amended so that we can seek justice when in fact something is committed via social media, Facebook, through text messaging. It's one of those things I always added when I was issuing an order of protection. I would say, you understand this means you cannot text message the person, because it's not even in the order, but it is such a common means of communication. So it's a real evolving area of the law, and it does provide a lot of challenges.
Thank you. The next question is, do you support efforts around discovery and speedy trial reform that would strengthen due process protections and the right to a speedy and fair trial?
Well, New York State certainly has the right to a speedy trial codified in our laws. And as a court attorney, I am intimately familiar with those 3030 statutes. And I have written thousands of decisions with respect to speedy trial and the need to be mindful of those protections. It is certainly also within our state and federal constitution. I'm not quite sure. I think the question is probably more along the lines of someone being incarcerated for a certain period of time, and that's more of a constitutional protection. And there are certain factors that have to be examined to determine whether or not someone should be released from custody pending a trial based on that speedy trial protection. So I certainly, as a judge and in my work in Albany City Court, we have always had the golden rule is that no one should sit in jail. And I think that speedy trial, we have the constitutional speedy trial and we have the statutory speedy trial, which is basically a statement of readiness, but the actual bringing the matter to a speedy trial is one of the cornerstones of our country, that you're not going to sit and wait without understanding what's going on and without having a chance to be brought to trial and defend yourself. So I do support any efforts that we could put forth, but I do think that we have actual speedy trial statutes that are working as best they can. With respect to discovery, I do support open discovery to an extent. We have to be careful that any of the information isn't privileged and that we're not jeopardizing anyone by turning things over. So in that regard, I would support any reasonable reforms in that regard.
Thank you. Joel.
Thank you. I'll address the discovery part of the question first. The statute already requires district attorneys to turn over matters in discovery when they're requested by the defense within a certain period of time, and of course we comply with that. Very often my office turns over much more than is even legally required, because it's my feeling and my attorney's feelings that the sooner you turn over this information, the sooner you can resolve the case with the defense. There are certainly efforts out there to codify open discovery. Some states have gone that way. I'm not opposed to it if the legislature decides that that's what they'd like to do. I do have serious concerns about certain information being disclosed, and we can seek protective orders from the courts at various times, but I'd have real concerns about personal information, victim information, witness information being disclosed before it's required to before a trial, because that can put witnesses and victims' lives and safety at risk. With respect to speedy trial, up in our county courts for our felony cases, they receive lists almost on a weekly basis called standards and goals that come down from the administrative judge, telling them how much time they have to get their cases resolved, and they move them very, very quickly through the process because of that list. Where I've seen in my experience delays happen have been much more prevalent on the local court level, in our city, town, and village courts, where cases that are ready for trial languish month after month after month. And as prosecutors, we do not have the ability to force a judge to set a trial date or to set pretrial hearings. All we can do is request that that happen. And I've seen a lot of cases over the years take a very, very long time to get to trial because some local court judges are averse to actually scheduling it for a trial. And that's where I think the real battle lies in moving cases along.
Thank you. The next question is, as Rensselaer County historically pays assistant district attorneys lower wages than surrounding counties, what is your plan to recruit and retain quality employees?
Thank you. Well, I certainly have experience in taking up this fight. I can tell you that we've made that comparison to surrounding counties in the past, and my office has successfully fought for some increases in wage levels for assistant district attorneys. And that is much needed, and I'm going to continue to fight for that, because we do a very, very good job in the DA's office of training lawyers, training assistant district attorneys to become trial lawyers and to become very skilled negotiators and litigators. But when they attain a certain level of experience, they obviously become more marketable. And it's a good economy, certainly right now, and there's plenty of jobs out there for good lawyers. And it's hard for me to blame an attorney who has a certain skill set and a certain level of experience, who might be young and starting out and growing their family and having all sorts of financial obligations, including very heavy student loans from college and law school. It's very hard for me to fault them when they come to me and they say, you know what, I was able to get a job offer from a firm or even another DA's office and get a substantial pay increase. I have had attorneys who've left and gone into the private sector who've said to me, I'd really, really love to stay. I love this job with all my heart. I'm passionate about it, but I can't turn down a $30,000 pay increase. And I can't fault them for that. It's unfortunate, but it's a very common problem across New York State. I know DA Soares in Albany County, he was just quoted in the paper a couple of weeks ago talking about the large amount of turnover he's had in his office because of the very same issue. So it's something I have fought for, and something that I will continue to fight for, to not only recruit attorneys, but to retain experienced, competent lawyers to work on behalf of the people. The work that we do in the DA's office really deserves no less. Thank you.
Thank you. Mary Pat.
I'm not so sure that it's the salaries in the office that are really the root of the turnover in the current office. I don't think that many people go to a district attorney's office with the intention of making a hefty salary. I think ADAs understand what they're signing up for, and they're ready to do the job because they're passionate about prosecution, or maybe they're just looking to get some trial experience. I think what needs to be done in the Rensselaer County District Attorney's Office to retain staff is we need to create an environment that people want to work in. And the problem that I have identified in the office is that the assistants do not have the authority to dispose of their cases. There's a tremendous amount of responsibility vested in the DA, and the ADAs are often required to answer to the DA or his chief assistant before they can make any decisions. And what I have seen is a lot of frustrated attorneys, a lot of frustrated good attorneys who don't want to work under those conditions. So if elected DA, that would be my first priority, because that you have to have those attorneys ready and willing to work in order to make the office work. My second priority, if I were elected, would be to speak to law enforcement and find out where the lapse is. What's going wrong between arrest and dismissal? What do we need to do differently? I want to listen and to figure out what we can do differently. I think that attracting and retaining staff is all about making people want to work in the office and creating an environment where they feel valuable and where they have the authority to do what they need to do to get the job done.
Thank you. The next question is, what is one of your weaknesses?
My weakness would be that I'm a little too hard on myself, and I think that I can always do better. And this can be very annoying to those that live with me, but I really feel like I hearken back to something that was told to me in middle school, and I'm sure you've all heard it. To those who much has been given, much is expected. And I have had a benefit of growing up in a stable home, provided with an education. I've married a wonderful man who supports everything I do. I have 5 healthy children. I owe my community a debt. I owe service to my community. And I am very hard on myself because I know how much has been given to me and how much I need to give back to the world. And that is why I am in this race, in fact, because I sat on the bench and I saw a need, and I said to myself, there's no reason you cannot put yourself out there and try to do this job. So my weakness would be that I like to do things better every time, and that I'm a bit too hard on myself and rarely satisfied with the job that I do.
Thank you. Joel?
Thank you. Well, I think one of my biggest weaknesses is probably also somewhat of a strength, is that I'm a workaholic, and I'm constantly at the office. I'm constantly working. This is a job that demands that type of time commitment. In the last 4 years, I've taken 1 vacation for 1 week. And I've certainly been told by family members and a number of other people that I should take more time for myself and should take better care of myself in that regard. But to me, the job comes first and is much too important. The passion that you have to do a good job as a prosecutor requires you to dedicate yourself wholly and fully. You have to be all in. You cannot, and it's unfortunate, but I've put a lot of other things first in my life when it comes to work. And I've got a loving family that has understood that the dedication to protecting others sometimes comes first. When I went to Afghanistan for a year, my family, God bless them, understood that I was doing it for them, and I was doing it for all of us to try to keep them safe. And all the baseball games that I missed when I was an assistant district attorney and my kids were growing up, and all the parties that I missed and the occasions of going out, always took a back seat because I couldn't let down the office. I didn't want to let down the victims in my cases. So I suppose that could be deemed a weakness, but I like to think of it as a strength, because I think that is probably one of the most important qualities for a prosecutor to have, is the sheer dedication to the office and the willingness to do whatever it takes to try to make sure the job gets done right.
Thank you. The next question is, what is your stance on prosecutorial discretion?
I think prosecutorial discretion is a vital tool that prosecutors have. You're electing a district attorney to exercise good judgment, sound reason, to reflect the values of your community. We can't do that without the discretion to exercise those values and to reflect the judgments that we believe are best for the community. If we didn't have prosecutorial discretion, the laws could easily be written to just be formulaic, to say if you do X, you're getting Y. But that's not how justice works. Every defendant is different, every case is different. That's why justice allows district attorneys to exercise their prosecutorial discretion to give somebody a break when they really need it and they deserve it, or to treat somebody more harshly because they have an extensive criminal history and they're not remorseful and the victim is irreparably harmed. Prosecutorial discretion allows your will through your prosecutor to be exercised. And it should always be there. It never should be taken away from prosecutors. And the process for objecting to whatever discretion is exercised by a prosecutor is to get out and vote. Mary Pat.
Prosecutorial discretion is the heart and soul of why we're here tonight, because prosecutors are vested with that ability. The power that comes with this office and the ability to make decisions that affect people's lives is the reason why we are an elected, why it is an elected position. That's why you need to know who we both are, so you know how we're going to apply that prosecutorial discretion. Just because a police officer brings a charge to the DA's office doesn't mean it gets prosecuted. And there are so many factors that are going to go into prosecutorial discretion. But what I can tell you about my office, if elected, is that my discretion will not be used in favor of my friends or against my enemies. It will be used uniformly in every single case. I have the moral compass to know what a vast responsibility this office holds. And I held that responsibility dear to me when I was a judge in the town of East Greenbush, and as a court attorney to the many judges that I have served in the criminal courts. It's a huge, huge responsibility, and it's what our entire country is built upon. So I firmly understand how important prosecutorial discretion is, and I think it is so important that you know that I will never use it in favor of any political measure, in favor of any friend, or against any enemy.
Thank you. The last question, and I have to compliment you all. There's a lot of questions, and a lot of them are actually duplicates. So I just want to congratulate you all on submitting so many very good questions. The last question is, if elected Rensselaer County DA, how will you balance being tough on crime as well as smart on prevention?
I think that's an excellent question, and it really goes to the heart and soul again of why we are here. Being tough on crime is what you want from your prosecutor. We want the criminals to go to jail. But we also need to recognize that some of the people that come before us, we may have the ability to divert away from coming back to us. So what you need to do as a prosecutor is invest in our communities. We need to use what we have, which is the status of being a prosecutor, as well as any money which may come into our office through forfeiture funds, to benefit the community. Invest in the people that live in our community and give them opportunities so that they are prevented from choosing a criminal lifestyle. If it means investing in sports programs for kids, if it means investing in assisting the city of Troy in opening those swimming pools, that's what we should be doing with any financial resources that we have, because prevention is a lawful use of seizure fund, a lawful use of forfeiture funds. And that money should not be used for furnishing the office and for niceties for ourselves. As a prosecutor, you have a full obligation to all of the people in the community. So I want a prosecutor that's tough on crime, and that is what I will be. But I'm also mindful of the fact that if we can divert some of these young people away from the court system, then we're all big winners. So we need to balance each of those. And again, I think that's what you're all voting on, folks. Who's going to balance that? Thank you.
Thank you. Joel?
Thank you. Well, I'm the only candidate up here who's got experience doing just that. I'm the only prosecutor who's actually prosecuted cases in the state of New York, and you can look at my record and my experience in doing these types of things. It is a prosecutor's job to hold criminals accountable for their actions. And I'll tell you, with regard to my opponent's comments regarding forfeiture funds, that tells you everything you need to know about her lack of experience. It is illegal for prosecutors to use forfeiture funds for anything except law enforcement and prosecutorial purposes. I can't open the pools with forfeiture funds. I can't fund daycare programs with forfeiture funds. That would be illegal. And for my opponent to suggest that she is going to do that with asset forfeiture monies, if she's elected as district attorney, you should know that she cannot do that. And if she does that, I guarantee it, she's going to get into big trouble with the state, because we are not permitted to use asset forfeiture funds for illegal purposes such as that. It's very, very strictly outlined in the law as to what asset forfeiture funds can be used for. My office holds people accountable every single day. Prevention, I'm out there in the schools talking to kids about not joining gangs. I've partnered with the U.S. Attorney's Office in doing that every year that I've been the elected district attorney. I go out and talk to grade school kids about not joining gangs. I've been to our schools to talk about prevention as far as the opioid and drug problem that we have. I've been to our senior centers and developed materials to help our seniors avoid becoming victims of abuse and what to do if they are victimized. And I've gone around to all of our senior centers and talked to them about these issues. So the district attorney's office plays a very important role when it comes to prevention and the education and the outreach. And I have done all that. So all of the things that my opponent has said that she plans to do or would like to do, I'm the one who's been doing it. And I'd like to use my last red card if I could.
A minute and a half.
Yes.
You know, one of the subjects that has not come up yet, and I'd like to discuss it, is the SAFE Act here in New York, because it's very, very important. And it's one of the reasons why I'm fairly certain that I've been targeted by politicians on the state level, because I've been such a vocal opponent of the SAFE Act. I believe it's unconstitutional. I believe it unlawfully punishes law-abiding gun owners in this county and in this state. And I'd like to know from my opponent if she plans on enforcing the SAFE Act, because I stated when I ran 4 years ago, and I'll reiterate now, I believe that trying to turn law-abiding gun owners into criminals by outlawing what they otherwise had lawfully possessed is wrong, and I will not prosecute somebody for that. And that's where that prosecutorial discretion comes in. And I think that the voters deserve to know whether or not my opponent, and she has time because she can use her last red card, where she stands on the SAFE Act and the Second Amendment, and whether or not she intends to enforce it if she becomes a district attorney.
Thank you.
Is that a question, or do I use my red card?
You can use your red card.
Okay.
1.5 minutes.
Wow, I got a lot of things to say here. First of all, I'm not sure how many times I have to say it and how many times you're going to refuse to listen, but I am a supporter of the Second Amendment, and I am opposed to the SAFE Act. I know my opponent doesn't want to hear that, because it's what he's got in his corner right now. So we don't disagree on that issue, and every time I've been asked, I've stated that, and he has decided to repeatedly state that I don't support the Second Amendment, which I take great offense to. But let's just go back to that forfeiture issue. You absolutely can use forfeiture funds for prevention, and there is a certain school of thought that if you invest in our communities and our children, that can go under the auspices of prevention. I also stated that we should use our position and any money available to the office to invest in our communities. Obviously, if I cannot use that money for those purposes, I would not. I would just like to make that clarification before my opponent goes back and tells everyone on Facebook that I'm going to illegally open pools with forfeiture money.
Stop.
And I'd like to also let you know that forfeiture money was used by my opponent to purchase himself a vehicle and vehicles for his investigators. And that money was not used to assist law enforcement or our community. Thank you.
Stop. Please. We will now have closing statements. Each candidate will have 2 minutes. I want to thank you all, both candidates and the audience, for demonstrating your civic concern by attending this event, and for the respect you have shown throughout the evening. Don't forget to pick up league material on your way out, but most importantly, don't forget to vote on Tuesday, November 6th. The League wants everyone to vote and to be confident that their vote will count, but also to be informed voters. Participate in your government, let your voice be heard, exercise your right to vote on November 6th. Now, Joel will begin with his closing statement. You have 2 minutes.
Thank you very much. Thank you all again for attending this evening. Thank you again to the League and to RPI. You know, voters often express a complaint that it's hard for them to tell the difference between two candidates because they may be very similar in their viewpoints. I don't think the differences could be any more stark as far as our experience is concerned. My opponent has never prosecuted a single case in the state of New York. Her experience comes from sitting in the courtroom or in the back room of a court as the law clerk for judges and sitting on the bench in East Greenbush Town Court. Both of those courts are misdemeanor level courts. She's never appeared in county court in New York State. She's never tried a case in New York State. I still don't know if my opponent has ever tried a case when she spent a very short period of time in Vermont handling criminal cases and family court cases. And to elect a district attorney who has no experience actually doing it is frightening to me, because how do you expect the district attorney to train and mentor those young attorneys coming up to do a job that she has never done herself? How do you expect her to be able to step into the shoes of an experienced prosecutor and try a case when she's never prosecuted a case in this state? That is the difference in the choice that voters have next Tuesday. And to entrust the significant position of district attorney to somebody who says, well, I've watched it happen, is like saying that my daughter loves watching Law & Order, so she's qualified to be district attorney. It's not the same thing. There's a difference between seeing it, watching it, and actually doing it. And experience counts more than anything in this job. I'm proud of our office and our conviction rate. I'm proud that I used asset forfeiture funds to save the county lots of money for cars that were needed, desperately needed, to replace the fleet for the DA's office, for our investigators to get around the county, that were purchased off of state contract. So I'm very proud of the work that we've done in the office, and the difference couldn't be more stark. And as far as the SAFE Act is concerned, I've written about it and I've talked about it. I've never heard my opponent talk about it until tonight.
Thank you, Joel. Mary Pat.
No,
I said thank you too soon.
I'm sorry.
Mary Pat, you have 2 minutes.
thank you. I too agree the difference could not be more stark. I'm kind of surprised he's going to go there. No, I have not been a prosecutor in the state of New York. Ladies and gentlemen, here's your experienced prosecutor. He's been indicted. The matter is on appeal. There's a motion to re-argue pending. And that is because he has politicized his office, and he has used his power against his enemies and in favor of his political friends. I don't know why he was prosecuted. I am not a puppet of Andrew Cuomo, by the way. I am an independent judge who saw an office that's not being run properly, and that's why I am here. And the experience that I have is absolutely crucial to running a district attorney's office. It is knowledge of the law, and it is the ethical backbone to do the right thing all of the time. So I've not been a prosecutor, but I've also not been investigated by a grand jury, and I've not been indicted. Thank you.